difficulty at 3 p.m.
3 p.m. it won't be called. There are 22 matters that are fixed at 3 p.m. At 3:30 and all, it is fixed at 3 o'clock. So that I could come on Tuesday with the liberty. I'm taking this liberty from the court that I'll indicate to the learned trial judge that the matter is fixed on
He's
Tuesday.
appearing for the other side.
Prateek Mukherjee.
If you can inform him, I can take it up at 3 p.m. today.
I shall do.
এটাকে 3 p.m. প্রথমে ডাকবেন।
Very good.
ঠিক আছে? Please inform, ask your advocate on record to inform.
With the leave of the Honorable Court, may I be permitted to mention one matter? Lordship, this matter, my junior has mentioned 7 times, but it is not coming in the monthly list, not in the days list, not for the fees. Lordship, that is for the
Under what heading?
Lordship,
Under what heading?
it's application for restoration.
Application for restoration. When did your junior mention?
Lordship, 6 times, 6 to 7 times. I know personally.
What is the last day when he or she mentioned?
Last week, Wednesday.
Taken in.
Lordship.
Because these applications will appear in the monthly list. I do not know.
That's why, Lordship, for last 3 months, I'm sending him regularly.
Yes.
Lordship, can it be fixed on days list?
No, monthly list, not the days.
Your Lordship, extension for interim order, Lordship.
Extension of interim order, please hand over this. Yes, call the list.
Milord, may I be permitted to mention a matter, Milord? This matter, as a matter of last chance, it has been fixed on 23/7/2025.
Yes.
Milord, the petitioner is defendant in the
Why did you not mention last Wednesday?
Milord, because Milord, on Thursday, Milord, the intimation was served upon me.
All right.
Milord,
Nothing-
kindly, Milord.
Nothing will happen. Yes, call the next matter.
7-2 has been rejected, Milord, and it is defendant's witness.
Yes. High Court cannot proceed as per the date of the learned trial judge. Yes, call the list.
Number 2.
Since I'm not inclined to take up this matter on personal.
My lord, I have instructions to withdraw the matter. This is the communication given to me by the client. It may be taken on record.
Yes,
Lordship.
the learned advocate.
Number 4.
I am appearing on behalf of the petitioner, my lord.
Yes.
In this matter, that this revisional application has been filed, praying for, my lord, early disposal of a non-mandatory petitions in the proceedings, my lord, pending before the ADJ Howrah. My
Yes.
lord, but instead of, my lord, that date has been mentioned in the order, my lord, is wrongly mentioned, my lord. My lord, kindly see the order date, my lord, 28 January 2021, when the non-mandatory petition was filed. But my lord, your lordship has a third paragraph of the order, my lord, 21st February 2025, my lord, instead of, my lord, 28 January 2021. And my lord, it is the last of the order, it is fixed for passing order.
23rd of July has been fixed for hearing of the petition date. It should not be 21st of February. It should be 21st of January.
28th of January 2021. Order dated, my lord, 25.
No, please kindly come to last order, 27th of March.
March, my lord. 27th of March, yes, my lord.
Yes.
My lord, the hearing of the petition date.
Fixed 23rd of July for hearing of the petition date, 21st of February.
This is not my petition, my lord. It is a
May not be your petition, but it's,
my lord, kindly see the next line, my lord.
and the order that is
Petition. That is the order is not passing, my lord. The several date has been gone. That is a file.
what is the hearing of the application dated 21st of February? What is the application dated 21st of February?
21st of February, my lord. 21st of 25. My lord, they have filed the application for stay, my lord. Since, my lord, is a time-barred petition, my lord, the beyond the time, my lord, the section 34 could not be filed, my lord, according to law, my lord. That is why non-mandatory petition was filed. my lord, kindly see the list of dates at once, my lord. My lord, kindly see list of how many times it has been heard. My lord, kindly see the list of dates, kindly.
আচ্ছা ওইটা yes.
Lordship, it is respectfully submitted that there is a minor correction required in the order dated.
Yes, what is the
Eleven-
correction?
Correction is that, my lord, the reference of the order 13 rule 4 of the civil procedure, it was inadvertently omitted and need to be specifically included in the order sheet.
No, I could not follow. What has been omitted?
Order 13 and rule 4, which is not included in the order dated 11/7/2025. I request you, my lord,
No, where it has been stated, there is nothing has been stated with regard to order 39 rule 4. Please kindly come to the order dated 3rd of March 2025. It has been said that section 151, order 7 rule 11, order 18 rule 18, order 11 rule 3 and order 13 rule 4. Order 39 rule 4 has not been stated there.
In the, my lord, sorry, my lord. In the application, my lord, I have stated, my lord.
You have
I
stated
am
the application, but the order states this. Order does not say order 39 rule 4. That's the difficulty. How do I know? See the order dated 29th of September 2024 also. Order 39 rule 4 is not there.
My lord, kindly have a look, my lord. Order number 23, my lord, 3rd March 2025.
Order number 23.
Last one, my lord.
Yes.
Order 13, rule 4.
Where is order 13? Where do you find order 13 rule 4?
Well, last
Order 13 rule 4.
order 13, my lord.
Yes, that has been recorded. Order 13 rule 4 has been left out.
Order 11, my lord. That is the, my lord.
Order 11 rule 3 has been mentioned.
No, my lord, my is order 13, rule 4. That has been, my lord, not recorded, my lord. Subject to lordship's correction.
Not order 39 rule 4.
No, no, no.
Achha.
Order 13, rule 4.
It has been pointed out that in the Yes,
My place.
that matter. I'm keeping it on Monday. All right,
But, instead of Monday, take it up on Tuesday.
you have been hard,
Yes, my lord.
so no further hearing. I will be dictating orders. I think that is
My lord.
that day I will find time to dictate it.
My lord, there will be probably nobody from this side to my lord, represent. Assist.
No, let me see if anything, then I will post it on.
So very grateful.
Because today we are
So very grateful. Grateful.
not today করে রাখুন. Yes, next.
Number 8, for the petition applying for
Yes. No, not today, sir. Then you will come and make some for upgradation. Not today business. Please start. Then once it passes over, you will come and say upgrade. Why it is gone down? Please move. দুটো কেন? 247.
another comments. That's why praying for outcome. This was a, that's why I got it.
This application under Article
For the
yes.
plaintiff is the petitioner before your lordship. Order as my lord is miscellaneous appeal arising out of an order of temporary injunction rejected.
Temporary. Yes. What is the suit for?
The suit is for declaration. Plaintiff is at page 30. The matter relates to my lord an society.
Yes, what is the infirmity in the order?
My lord, certain facts which are neither the case of the plaintiff or the defendants that has been brought by the learned.
What is that case which is not the case of the plaintiff or the defendant? Show me.
My lord, kindly comes to the impugned order.
Yes.
The brief facts and just skipping 2-3 paragraphs. The defendant by filing written objection have denied all the contentions of the plaintiff by contending that the association.
Page 3.
Page 4.
Page 4 of the appellate court's order.
Court's order.
Where is the yes?
The contending association represents an unrecognized organization. It is the specific defense of the defendant, respondent, that his tenure continued from 2010 to 2014 and thereafter from April such and such. Thereafter, the defendant was given permission by the Taekwondo Federation of India to hold election of Bengal Taekwondo Association within a maximum period of 6 months under article such and such. The defendant respondent claimed that his tenure was extended for a period of 12 months by the Taekwondo Federation of India. The respondent has further stated that her lordship Justice Rekha Palli, in her order passed in WP such and such, has been pleased to appoint court commissioner for conduction election of Taekwondo Association of India, wherein the said electoral college Bengal Taekwondo Association is to be represented by Sanjay Singh as president and the defendant as the secretary of the said organization. These were, my lord, neither, my lord, the part of records it is the categoric contention of the respondent defendant that the plaintiff has filed his nomination for the Taekwondo Association election, which is slated to be held on 2nd/4/2017. But his nomination was rejected by returning officer as the nomination form was submitted after the expiry of statutory period. Moreover, on such and such a general, what happened in this particular organization, the elections were scheduled to be held in 2017. The plaintiff participated, was elected. The defendant, who was the earlier office bearer, he assumes charge and he elected himself. All these facts have not been considered by both the courts.
How can that be done in injunction? I'm expediting the suit. Can it be done at the interim? Because that is the final decision which has to be taken.
And also, my lord, the kindly sees the decisions with reasons.
Yes. Where is the order of the trial court?
The trial court order is annexed at page, my lord, it is 8th of July, page 25. Kindly sees the reasons of the appellate court below. Only, my lord, plea that the civil suit has been instituted at a belated stage. And there was also no explanation by Shamanto Group.
That is also one of the grounds for refusing to injunction. That is also one of the grounds.
My lord.
So you have approached the court at a belated stage. I can expedite the suit.
Also, your lordship kindly sees the original, what happened, my lord, the earlier, the defendant who was in charge, my suit is for a direction so that he,
You are Samanto group.
No, that is the, my lord, this is.
You are which group?
I am, my lord, the plaintiff is Subroto Banerjee. Samanto group is neither here nor there. No, that is my respectful submission before your lordship.
Show me your plaint.
My lord, plaint is at page 30. My cause of action is at paragraph 12. This is the actual dispute between the parties.
Where is the written objection? So your prayer is mandatory injunction directing the defendants to hand over the documents. How that can be done at the interim stage without hearing the suit?
It is final relief matter.
Yes, so that is the final relief. So if the documents are given to you at the interim stage, what remains in the final?
And what happened, my lord? I am not in a
I am
position-
expediting the suit.
And my lord, elections were not held. May I
That
complete
is
after serving the
where held because their case is that by way of selection or consent, some persons were elected. So that has to be decided in the suit.
My lord, since 2017, the next period has, my lord, forwarded, my lord. Again, what happened? The defendant nominated her wife, and now,
What is the next? When is the next election due?
my lord, from 2017, it was due 2021.
Yes. Now, when is the next election due?
My lord, 2025.
2025. When?
My lord, that I have to take instruction because 4 years, 17, 21, now 25.
25. So we are in
Now-
2025. So I think suit also cannot be disposed of in the meantime.
No elections. We are concerned not about my.
So next election you contest, become successful in the next election. Ashun. Yes,
Earlier occasion, Lordship, there was an order from this honorable court to dispose of the title suit of 2021 within a period of, Lordship, 8 months, Lordship. That is at page 33.
yes.
Now, Lordship, in spite of the order, that order, Lordship, continuously one after another, Lordship, DW is producing without prior, Lordship, giving the list of the said witnesses. Now the learned court is allowing and the cross of the DW is going on. Now, Lordship, since 2023, Lordship, the suit is at DW stage. The suit for, Lordship, recovery of khas possession. I am suffering, Lordship. I have an prior decree of, Lordship. September 2023, Lordship, an order of
This application under Article 227 of the Constitution of India is at the
only one DW1 was produced. Thereafter, one after another,
there
Lordship,
are liberty to produce witnesses.
they must, Lordship, supply the list before, Lordship, before.
They
within-
challenge that. If they do not oppose that, apprise the learned trial judge that
Should
they have
be,
to
Lordship,
file a list of
concluded.
witnesses.
It should be, Lordship, concluded with.
Did you file the list of witness prior to?
Only one witness I have completed.
No, no. Did you file the list of witness prior to that?
Yes, yes. Within, Lordship, after
Sure you have filed
after
the,
framing of the
are you sure you have filed the list of witnesses?
list of witnesses along with the, Lordship, documents was filed. Lordship. Along with the, Lordship, all evidence was filed. So kindly, Lordship,
Yes, call the
let's
next
say
one.
time period be, Lordship.
There is direction, further direction. He will again come up saying 2 directions have not been complied with. No use.
Only within that period from the, Lordship, because the next date is, Lordship, fixed on
Within which period?
within, Lordship, next 6 months at least basically should be concluded, Lordship.
Then he will come the initial 8 months, then 6 months, again on civil division application.
Now, Lordship, only the recovery of khas possession suit is, Lordship, going on, Lordship.
Yes,
from
yes. What is the next
2020.
matter? Yes, this application.
Application I'm praying.
Matrimonial suit. Who are you?
Yes, I'm for the husband, your lordship.
Yes.
Petition, your lordship.
Alimony?
We are paying your lordship.
Yes.
Your lordship,
What is the stage of the suit?
your lordship, I have deposed, my examination in chief has been done. They are not
Examination is at the stage of
cross-examination.
cross-examination.
They are continuously taking time for cross-examination, your lordship.
All right.
Almost a year has passed.
This application under Article 227 of the Constitution.
I beg your lordship, my lord. My lord, petitioner filed, my lord, a suit for declaration, my lord, and
Yes.
obtain an order there. My lord, page, my lord, initially may I tell your lordship?
Yes, what do you want? Expeditious hearing
Yes, my lord.
of what?
Actually, of the suit, my lord.
Of the suit. So do I have any difficulty in taking up this matter? From Baripur court, who is your counterpart in the court below?
My
Who is the
lord,
learned advocate appearing for your client on the other side?
on the other side,
Your for your client on the other side, who is appearing?
my client, my lord, I also be there, my lord. I also was there, my lord.
Who is appearing for the other side?
Other side, my lord,
I'm passing it over. Please take the instructions and come.
my lord. My lord,
1 p.m. Please take instructions. Who is appearing for the other side?
other side, my lord.
Yes, yes.
My lord,
Call the
other side also filed a suit, my lord, that I mentioned.
I know. I want to know the
My lord.
name of the learned advocate.
Number
Yes.
13.
But 13, I am appealing for the petitioner, my lord. This is an application for early disposal of the suit. My lord, suit is of the year 2019. Suit filed under section 2G of the West Bengal Premises Tenancy Act. But the defendant, my lord, learned advocate for the defendant filed an application for 7172 for last 2 years. That application is kept pending, and your lordship will find that one after another day, my lord, it is adjourned. Last occasion fixed for evidence even, that has not it been produced. Hearing was concluded prior to that.
This application under Article 227 of the Constitution of India
It is also an application for expeditious hearing of the suit. Mala, it is a suit of 2009. And
what is the stage?
Mala,
Examination of PW1.
PW1, Mala, 23 started. Mala, it has not.
This application under Article 227.
matter, I am appearing on behalf of the plaintiff petitioner, my lord. They sued for eviction on the ground of reasonable requirement and default, my lord. The 7-2 was disposed of with a observation that the admitted area rents was deposited with along with interest. Admitted area rents was deposited along with interest, statutory interest in the 7-2 application. In 7-1 application, they only the current month they have to deposit.
Yes, you are the plaintiff.
I am for the plaintiff.
Yes, why are you aggrieved?
My lord, they have, he did not deposit the admitted area rent in the 7-1, man.
At the time of filing of this application. So what is the suit for? On what ground?
Reasonable requirement and default. I have stated paragraph.
Why are you trying to delay your own suit, sir? On 7-2.
My lord, it is at 7-3.
All right.
Then, my lord, not this.
That is why I asked you. 7-2, when is the suit on the ground of reasonable requirement? Otherwise, this has to be done. They have to come. It is to be decided. Because serious consequences, if it is rejected, defense will be stuck over under section 7-3. If the suit proceeds, it's a different thing.
No, my lord.
Yes. Have you taken instructions to withdraw?
No need.
Yes, next. Without instructions, don't say that not pressed. It will be a difficulty. Yes, next.
Number 16.
Sir, to the
My lord, I am for the petitioner. This civil litigation application, my lord, in connection with the execution proceeding. My lord, the contested degree has been passed in the year of 2000.
Yes, which order you are challenging?
My lord, degree has been passed 2014. Then, my lord, I have execution case has been filed. As per the direction, I have deposited the police cost.
Yes.
The two number of miscases has been filed by the third party. And there is no stay, no appeal, nothing. But after receiving the police cost, the executing court not executing the degree. My lord, kindly see for a moment.
Which is the order under challenge?
My lord, the challenge, my lord, kindly see the imprint order, last order.
Yes, what is the date of the order?
Last page, my lord.
9th of June.
Yes, my lord. From 2023, this court is fixing date for orders after depositing the police cost for executing degree, my lord. It will be clear, my lord, if you see, my lord, kindly see the order, page 89. My lord, kindly see for a moment page 89.
Yes.
Today is the date fixed for passing order. Degree holder files Hajira along with affidavit of no stay. The court of the view that if order is passed, then the purpose of the filing miscase will be frustrated. So the order is reserved. Order would be the execution through bailiff with the assistance of police. I have deposited the police cost since 2023.
The
There
learned
is no
advocate
stay.
appearing for the petitioner submits.
Money is, my lord.
Yes.
Item,
Grateful, my lord.
item 17, my lord, I've challenged an arbitral proceeding here, my lord. I am aware, my lord, of the limited scope involved in interference of this honorable court, my lord. My only ground is, my lord, the arbitrator who's proceeding with the matter to my client's prejudice is a unilaterally appointed arbitrator. The honorable Supreme Court has now held that all unilateral appointments are, my lord, bad in law. Here, the shocking thing here, my lord, is the advocate who has issued a demand notice on behalf of the claimant, he himself appointed himself as arbitrator, and he's proceeding with the matter. Now, the order impugned, Mullah will kindly take 183. Mullah, here it's
No,
Xerox copy.
the order you have challenged.
I've challenged the entire proceeding.
Yeah, what you have challenged? No.
This is not at the award stage. I'll indicate what has happened. I was asked to enter appearance before the arbitrator. I had written to them saying, you are unilaterally appointed, you have no jurisdiction. Thereafter, they still proceeded. I filed a section 16. Section 16 is pending. Now, what the arbitrator is trying to get us to do is file a statement of defense. Statement of defense before even deciding the section 16. I am only seeking the limited direction of your lordship, but only for the arbitrator to decide the section 16 first before asking me to file a statement on merits. This is a unilateral appointment.
Order. Which order you have challenged?
183, my lord, will kindly have.
Page 183.
Yes, my lord. My lord, there is no certified copy because these are arbitral proceedings, my lord. 183. 183 at 184, the last paragraph, my lord, will kindly have. Section 16 has been filed. Now the arbitrator asks us, Lord, the matter is again adjourned to so and so for filing of the reply of the SOC filed by or on behalf of the claimant.
26 June 2025.
Yes, my lord.
Page 184.
184. 184, my lord.
Yes, 184.
184, the matter, the last paragraph, my lord.
Yes.
The matter is again adjourned to 11 July 2025 at 3 p.m. for filing of reply of the SOC filed by or on behalf of the claimant and the application of section 16. Filed by the respondent number 1. I am only seeking, my lord, a limit.
Where is the letter you have said that the
yes, my lord. I'll indicate.
Same advocate issued a letter.
First and foremost, my lord will kindly have the demand letter that's at 122. 122, my lord will kindly note the first, the head, my lord, the letterhead, PM Sharma and Company. PM Sharma and Company at 122. This is the advocate acting on behalf of Roto Pumps. That is the claimant before the arbitrator. Well, the signature of the learned advocate is also there at page 132. 122 and then 132, my lord will find the name of the learned advocate issuing this letter on behalf of the claimant.
132, my lord, will see the advocate's name, Pavitra Mohan Sharma, and thereafter, my lord, immediately the letter from the arbitrator, 135, causing us to enter appearance. Pavitra Mohan Sharma, advocate appearing for the claimant, writing letters on behalf of the claimant, is now calling us to appear. I file a section 16. He says no, section 16 will be heard, but after you file a statement of defense. Absolutely perverse, without jurisdiction. The Honorable Supreme Court has
Arbitration একটা দিন তো।
Arbitration Act. And 4.
Entry
Entry 2, 3, and
3 and 4.
Yes, currently represents the lawyer or firm acting as counsel for one of the parties. All of them they're hit. Absolutely hit by the schedule, my lord. He's also hit under the 5th schedule, but 7th schedule is good enough. Section 12 is the bar.
What have you paid for in this?
My lord?
What have you paid for in this civil revision application?
The praise, my lord, I've challenged the entire proceedings. It's not challenging of one particular order, but I've annexed all the orders, my lord. I'll correct the praise, my lord. My lord will grant me leave, I'll correct the praise. My only urgency is, my lord, 25th July is the next date of hearing. My lord, will kindly stay the proceedings for a limited time at the very least, my lord. Or, my lord, will take.
The
Lord, the Lordship can guess, Lord, what's the matter about, I'm sure. Order 7, Rule 11.
Both of you have by now become experts in Order 7 Rule 11. Mr. Banerjee also, same thing applies to Mr. Banerjee also. So now
But,
since both of you are in the same matter,
It has to be rejected. Has to go. Without
the other way around.
Other way around. My Lord,
Yes.
if your Lordship looks to, my Lord, the impugned.
What is the Rule 11 rejected?
My Lord,
What is the suit for?
suit is, my Lord, for recovery of possession, and challenges, my Lord, a partnership deed. Rather, is based on a partnership deed where, my Lord, the plaintiff wants money out of that partnership deed. My Lord, I have a very different submission than what has been, my Lord, made, my Lord, in the trial court. In the trial court, we filed an Order 7 Rule 11 on the ground, my Lord, that court fees were not paid and the suit is undervalued and things like that. But I feel, my Lord, and with rather, my Lord, he feels, and I also, my Lord, feel that this is a commercial dispute. This point was not taken in the trial court. But, my Lord, it is the
Then
duty
return of claim.
No, the rejection. After
12A.
not exactly. Exactly. So if it's a
Mr.
commercial
Chatterjee,
dispute,
unless you take this point.
it is the duty of the court to see whether it has jurisdiction.
Yes, yes.
But this is
Mr.
inherent lack of jurisdiction.
Mr. Chatterjee, I am not for a
Your Lordship.
disputing that.
I'll serve the other
give-
side.
I give you liberty to file an application because these points were not taken.
No,
till on a trial was also
no, I'm
did
on
not
a
answer.
different footing. Well, I'm on a very different footing. My footing is that if on the basis of whatever of the plaint itself, the court should not have even admitted the plaint because it lacks inherent lack of jurisdiction.
Yes, but
Well, it's the
Chatterjee,
duty
this
of the
was-
court to see jurisdiction and limitation.
was not argued till on a trial that.
Well, it is the
did
duty
not-
of the court. Well,
I appreciate that.
This can be remanded back. Let it serve and come back.
I give you, Mr. Chatterjee, these points were not taken.
No.
So if these points were not taken,
Then even on the
question of
point-
res judicata also does not apply.
No, even on the point taken, I'll show your Lordship.
On the point.
Even on the point taken, I'll show your Lordship.
No.
That there is something wrong there.
No, that is a different thing altogether. I give you liberty to file an
Well,
application.
if I can show from the order impugned itself that there's something wrong, then your Lordship would interfere on that, number one. Then, then there is this massive point, Willard, of the court has lacking inherent jurisdiction. It has inherent jurisdiction to
Then
even
return of the claim. If you say,
Supreme Court is now saying, Willard, if it's commercial, it has to be rejection of claim. Because 12A has to be complied with.
that is a different thing altogether.
So that's why the Supreme Court says no return, rejection. No return. Specific the judgment on that. No return. I don't have a problem on return. But the Supreme Court says, Lord, that it has to be rejected. Because it can't be, Lord, from 12A.
12A, Mr. Chatterjee, no,
And-
you say it's a commercial dispute.
Yes.
Filed as an ordinary suit,
Filed as an ordinary suit.
money suit.
Money suit, recovery of possession suit.
What is this suit for?
Money suit, recovery of possession, everything paid from a commercial transaction. The property being used to
Specified value.
or specified value. It's a restaurant being run, my lord, at Sharat Bose Road. And the deed on
If
which
you want closure of the restaurant,
they want. It's a Bengali restaurant, my lord, run, my lord, in Sharat Bose Road. That, my lord, they want closure of.
why?
But they say that I am not paying them money.
Pay them money.
We will, ready.
Pay them money.
Ready.
Sending to
Paid.
sending to mediation then.
Mediation hai hum jao. No. Nothing has been solved in mediation ever.
Yes. Why do you say? Mr. Chatterjee, 3 matters. On the report, disposed of. 3 matters, I tell you. And this is a type of dispute. If it is involving partnership business, I think it's the best.
Very well,
thing
let
which
them
is to
come,
be-
your lordship would say.
Because I tell you, Mr. Mukherjee, Mr. Probal Mukherjee was appearing.
He has become, my lord, very, I was speaking to him the other day. He's become very adept at mediation.
Something,
to
if
the
it
profession.
goes to those accounts and other things, if you go to a right person, that's important. then I have, after getting the determination, 3 matters are disposed of in mediation. One has been solved, report has come, that matter will come. So fourth one. That is why I'm telling you, considering the disputes.
Very good. Let them come, we'll try and do that. Let them come.
In this suit, 119.
Of 2025.
Yes, this suit.
This order.
Maybe, please serve upon the learned advocate.
Directs me to serve on that. I have no problem.
Service.
Look, there is another order which is under challenge. They have lodged a caveat with respect to that, not with respect to this.
What is the date of this order?
Date of this order, my lord, is 13th of June 2020.
Mr. Chatterjee, why do you say? Yes, please check up.
No,
This is not expected.
no. If that is so, my lord,
There are 2 endorsements. Please see the second endorsement.
has been lodged.
Has been. I've checked up.
আচ্ছা এটা নিয়ে তর্ক করার দরকার আছে কি
It has been lodged by the mobile number against Atto.
There are 2 orders. Both have been referred to. Both against caveat has been lodged.
My fault. It's my fault.
No. This is happening and the
No.
sometimes allegations that the other side is misleading. When the caveator is coming and saying, I have lodged the caveat, other side is saying he is misleading. There is no caveat.
No. This is my fault. My lord, kindly directs us to keep it on Tuesday or Wednesday. We'll serve and come back.
Mr. Chatterjee, Lawrence, senior advocate.
Number 19.
Yes.
তুমি যাও যাও
এটা আবার কি? Yes.
And stay has been declined by the corporation tribunal in respect of
Expert in unauthorized construction, Mr. Bhattacharya.
no. Huh? He
experts in unauthorized construction.
Nothing. Toddler, still learning every day.
Yes, yes, what happened?
Not 330 square feet is in dispute.
Shop room, parking
No,
space.
Old building in North Calcutta which was purchased, and there was remodeling done. They allege, the complainant alleges that there is some illegal construction. The illegality is recorded in one of the orders of the corporation.
Which for the corporation?
No caveat by the corporation. My learned friend will not serve the caveat. We have served it.
Yes.
Now, today the difficulty is what is prompting me to come to your lordship. My appeal has been kept, hanging. The stay has been declined. The appeal has been kept pending, and the appeal is likely to appear in the month of December 2025.
I'm directing the appeal to be disposed of on 16th.
In the meantime, they are going to execute the order.
Yes, till that time, not to execute, I'm directing the appeal to be disposed of.
Disposed of in a time frame,
Yes, but where is the municipality? Please bring municipality. Which municipality?
Kolkata.
Bring Mr. Ghosh or any other advocate.
Serve him,
Mr. Bhattacharya, can you not bring him?
দুটোর সময় ভাই আমি যদি ওখানে আটকে যাই yes kindly keeps it at 2 p.m. irrespective of anything first any advocate appearing for the corporation or is it any your lordship Alok Ghosh?
No, I'm not giving any particular name. Anyone who represents who can appear because otherwise it will be kept pending. I can because of that.
শুভ্রাংশুকে কপি দিয়ে
পাসওয়ার্ড করে 2 p.m. এটাকে 2 p.m. করে দাও। Yes, next.
And for the opposite party, my lord, this is with regards to that custody matter, my lord.
We have been served with the opposition, my lord, only last week only, my lord. The reply is almost ready, my lord. It is not.
Easier for my learned friend, my lord. I am going to seek a leave, your lordship. What has happened in the affidavit of opposition, certain pertinent documents inadvertently didn't go in. Plus, my lord, subsequently, till last Tuesday also during the visitations, certain incidents have occurred which we want to also bring on record, which is pertinent for these disputes between the party. Only seeking leave to file a supplementary affidavit within a week, my lord. They can give a composite reply to the opposition.
Supplementary affidavit in opposition.
Only one thing,
Supplementary affidavit in opposition. Where is your affidavit in opposition?
It's ready.
It's ready. Have you served him a copy?
I have
Do one thing. Why again filing this supplementary? This opposition again supplementary. File a composite.
One thing I'm praying,
I think that is better.
If your lordship grants us leave, we'll do.
Mr. Chattopadhyay, give him that copy.
Yes, I don't have any problem.
Have you served him a copy?
Yes, I've already served.
Yes. So I am recording your submission that you want 1 more week.
1 more week, my lord.
The learned
Kindly
advocate.
grants us leave for that, my lord, to
The learned advocate appealing for the any other representative.
They also, they are sending, Lordship will kindly record that, man.
This will happen.
I am having at least 10 mails, at least. I can show before your lordship from other side, they are objecting to that. Only Lordship will kindly record that.
fully clarified advocate can record.
I don't have any problem. Well,
clarify
I don't have any problem, man. If the learned.
On these minor issues, where
Well,
is?
I have already taken
We
the
are,
objection.
we are only, my lord, since your lordship's direction was advocate on record,
By which order I have said?
both the
Well,
advocate on
on-
records
probably
need
on
to be
last order.
present, my lord. Both the advocates need, from
But
both
this
sides
was
need
not
to be
stated.
present.
Prabhata, this is necessary because the,
Well, sometimes I'm not on regular basis. If in a
there
day,
may be some allegation.
Yes, your lordship, that is the
Please
difficulty.
appreciate if her learned advocate on record is there and you make an allegation.
well, I am not seeking for every day. Only if any moment, well, it might happen. Well, Lordship will kindly recall.
My lord, may I only say this, my lord?
Already opposite reply drafted now.
Then I'm taking taking it on record, I'm directing.
Well, I'll get you. I'll get you. On
দরকার
Monday.
নেই, এটা করে দিন।
No, no, Monday I'll get you. No, there is no problem. Not
Kindly take the.
13th of June, it has been said.
Yes, my lord, it reads, my lord, kindly reads the entire stamped version, so but no caveat has law. It is on at the bottom, last 3 lines perhaps.
It is a continuation.
Yes, ma'am.
All right,
I'm sorry,
start in a
I
copy.
will,
Yes.
sir. Just wanted
Yes,
to
next.
indicate that.
Item number 22.
My lord, the petitioner, my lord, on the last occasion, my lord,
Yes,
this is the case of Badipur Court, my lord. In the last,
yes, yes.
my lord has asked me to take instruction with the advocate on record for the appellant and the respondent.
Yes.
My lord, for the appellant Anarul Haq Molla and Sati Bhattacharya.
Yes.
And for the respondent, my lord, Chinmoy Chakraborty.
All right, then I can take up. Yes.
My lord, actually, this is a case for title suit for declaration of title, my lord, regarding gag number 1 of filed by the plaintiff, my lord. I am for the defendant there, my lord. I have, but while filing the case, my lord, he has taken gag number 1. Even my gag number 5 has been included with my at the plaintiff, my lord. I have objected, my lord. My
Who are you in the suit?
I am the defendant in the suit.
Yes.
Defendant number 2, my lord, in the suit.
What is the suit for? Where is the plaint?
My lord, Annexure 1, my lord, is Annexure A, my lord.
Yes. Where is your, what is your case?
My lord,
So this is a suit, they are claiming declaration of title in respect of court schedule property and for injunction.
my lord,
What is your right in respect of court schedule property?
regarding property, my lord, Annexure 1 is the property of the plaintiff. I am the defendant.
Yes.
In respect of plot 1, my lord. But my plot number 5 has been included in the said application, my lord. The title deed. That is the title suit, my lord. I have objected the same in the objection petition, and the matter was heard. Thereafter, the said was appealed in the misappeal, my lord. In the misappeal, my lord, I have also in paragraph 3, my lord, I have taken the objection that paragraph 5 is my land, but the learned court in plot number 5 is my lord, my land, but both the court has passed status quo order in the case. The order of the court 1, 2, and 5. What was the problem, my lord? In respect of, I want to expunge my name from from plot number 5, my lord, in the said suit. This is the actual.
No, but this is the injunction. Injunction, how can you expunge? If you want to expunging your name, you file an application there.
He has passed status quo, and the status quo has been affirmed by the learned.
Yes. What is the
senior division? But my drug number has been included.
But that has to be.
5 has been included, my.
What is your right in respect of that plot number? How have you proved that?
I am the.
I have the title deed, your
I have
lordship.
title deed.
Where is the order of the trial judge? Yes, please give me a minute.
And it's just C, my lord. Page 27.
It's 26.
Page 26.
Where is the injunction application?
Injunction law is not implemented. I have
No, they are paid for injunction in respect of which property? Cost schedule or cost schedule?
Cost schedule. Cost schedule.
cost schedule. Cost
Cost
schedule.
schedule.
Law. Law you do not have any right.
No, no.
Law you do not have any right.
Actually, your lordship, my plot number is 5.
Yes, 5 is in core, not core. Please kindly come to page 14.
Co. I am in co.
Yes, so core there is no injunction. Injunction is in core. How are you affected?
But status quo is running.
Status quo not in core, but in core. That is why I am asking you, where is the plaint?
I am in co.
That is why, so no injunction in core. That is the finding of the appellate court.
But
Status quo in plot number 4.
And that is also the, where is the application for temporary injunction? Because if you come to the appellate court's judgment, appellate court has not said anything with regard to core. The appellate court has said, please come to the page. There is no page number. Penal. This is the third page from the last of the appellate court. The documents relied upon by the plaintiffs prima facie go to show that they are the owners and occupiers of the scheduled property, and the defendants do not have a right to dispossess them from the suit property or raising any construction over co-scheduled property, not co. The allegations of the plaintiffs to the effect that the defendants are trying to make construction over the co-scheduled property and also tried to dispossess them.
in that case, my lord, kindly direct the case for speedy disposal. That is pending since 1980.
The suit.
Suit.
Yes. Ashun. After some argument, the learned advocate appearing for the petitioner
And for the petitioner. Well, there is an amendment application that was rejected. Against that, I am here. My lord, on the earlier occasion.
Here's my learned
I-
senior friend.
My lord,
Last order, my lord, was passed.
yes, on 9th
If your lordship
September.
wants
No
to.
service has been made.
No, my lord, my lord.
No, no,
is
my lord,
really-
if your lordship hears him, if your lordship finds, my lord, that there is anything, then, my lord, your lordship, my lord, I will make my submission. But I.
Were not serving copies. There was a direction on 9th of July.
Yes, yes, my lord. That, my lord, by mistake, it was, my lord, I am serving the copy on my learned friend just now, my lord. Kindly
Here's my learned
take
senior.
it on next date, my lord, on
no.
that.
Here's my learned senior.
All right, come at 2 p.m. There is one fixed matter, thereafter I will.
Item 12, my lord, your lord. Yes, item 12, your lordship asked me to, the name of the opposite party learned advocate, my lord.
Yes.
My lord, some Mrityunjay Babu is appearing, and the, on record, he served me a copy also where S. Pal is.
All right, then I am taking. Yes, what is this matter?
Suit for declaration, my lord, my application.
Yes. Which order you are challenging?
I am for expeditious disposal.
Expeditious disposal
My lord.
of what?
Or my suit, my lord.
Of the suit.
That is, my lord, page 18, start, my lord, perhaps order. And suit is
Item
page
number 12.
12.
কোন ফাইলটা দিলেন এটা? 12 ওটা।
না
My lord, I am dead by Mrs. Subhashi Sengupta.
Item number 12.
no matter 24 is the next matter, lordship.
12 has been called. 24 come after 2.
After great.
Yes.
Page 20 is the suit, my lord. The order is starting from page 18, my lord. Where I,
39 rule 4 is pending.
my lord,
Injunction application disposed of or pending.
my lord, pending. My lord, there already time is going on.
This
The
application
poor
under
people are
article,
there, my lord.
this application Yes, where is Mr. Chatterjee for the state?
I'm for the respondent.
Call Mr. Chatterjee, Nilotpal Chatterjee, or Mr. Sopon Man. Where are they? Pass over.
Item number 24.
2 PM ছিল তো 2 PM করা ছিল যে call item number 1.
Item number 1.
I have 23, my lord.
দাঁড়ান না, 1 নম্বরটা ডেকেছে তো।
Yes, Mr. Chatterjee, you have brought the keys.
In terms of my lord's order, my lord. ফোন করার দরকার নেই, আপনি এসে গেছেন জানানোর আমাকে কোনো দরকার নেই, তাই তো? কোনো দরকার নেই।
The impugned order directing On the next matter,
Item number
24.
23, my lord, I am for the 23, my lord.
Yes.
My lord, my lord, it is a case of amendment, my lord, order 6.
What is the food for? Amendment of what?
Amendment of plain, my lord.
Amendment of plain.
Yes, my lord.
Rejected.
Yes, my lord, it was rejected. Against that, I am here. My lord, the main context of the amendment is that he was an employee of
Your plaint.
my lord, plaint is at page 29.
Where is your amendment application?
My lord, at page 47. My amendment shortcut as page 48.
Application page টা কত? হ্যাঁ, সব delete করে দেবে।
Yes.
My lord, a lot of amendment is short for. My lord, only submission.
How could you delete some paragraph?
All.
How could you delete admissions? You can explain the admissions. How can you withdraw the admissions?
No, my lord, I will confine only the amendment portion, my lord, paragraph.
Yes, amendment.
Two, my lord.
Only two you want to amend.
Yes.
Other you are not pressing.
I am not placing, my lord. These will not be affected, my learned friend. He was a employee under this organization.
So 95.
What was there in the first line of the existing
95.
paragraph number 1?
Paragraph 2 of amended, my lord.
Page 49.
Please give me a minute.
Schedule of amendment.
Please give me a minute. The plaintiff joined on ATO at IFB referred to joined on April 1, 1995. In the first line, date to be deleted. Joined. Calling word sector employed as an employee.
Nobody is not facing, I'm not even getting into it.
Yes, Mr. Chatterjee, what do you have any objection with?
With respect to this, I can't have an objection.
Paragraph number 2, I'm recording his submission, that is because only the dates that is the 1995 or 2000, that's a matter of proof.
Yes,
That's fine. No, there's just one difference, but if your lordship sees.
My lord, kindly for a moment, kindly see that judge, my order, impugn order, page 60. My lord.
But there is a difficulty. Paragraph 2, please kindly come to paragraph 2.
Yes.
Paragraph 2, if you only change paragraph 1,
yes,
that you say that you joined from with effect from 1st of July, but the second paragraph will be contradictory.
Exactly.
Has been continuing service in the continuing himself with the service of IFB on retainers.
And says retainership, and there he says employee. So he's completely changing the nature of employment.
That is
Nature of employment is.
It will be also contradictory. Even if we assume that previously we are under retainership, subsequently employee, but some period is
retainership.
Yes.
Cannot happen.
These two things cannot go side by side. Ashun, this application stands allowed in part. Yes.
I propose a petition.
Item number 19.
19. Yes, who is for the corporation? Yes. Yes, are you going to demolish?
There is a notice.
There is a
Right
notice.
now I have an instruction has been
The
taken.
appeal is pending. Appeal is fixed on 16th of December.
Stay application is rejected and appeal is fixed for them.
So if the appeal is stay application rejected, you implement what remains to be decided in the appeal. So I'm directing the appeal to be disposed of.
If the Monday is fixed for demolition.
Yes, don't demolish.
That has to be set aside, my lord. That has to be set.
That order should be stayed and I
That has to
will
be set.
come back to your lordship.
No,
Because I
sir.
have no instruction.
Regular,
I-
sir.
All right.
Give us
I
specific prayer.
will be in difficulty.
All right. All right.
My lord, kindly consider one thing, my lord. My lord, a prima facie case has to be made, my lord, for obtaining
All
an
right.
order
He
of
wants to take
for administrative
instructions.
order.
He wants to take instructions.
Add, my lord, one, my lord, two things admitted. These, my lord, two
Mr.
things
Banerjee,
admitted.
there are two things. If you say yes, stay rejected, the order can be implemented, then I will decide, I will take it that the appeal has been dismissed also. I will proceed on the merits. Because no useful purpose will be served, keeping the appeal pending, executing the order. Then I will decide, considering the appeal has been dismissed. I will decide of the demolition order then.
Lordship, my lord, if your lordship, my lord, goes on to decide the appeal itself, my lord, I can stand in the way.
I will not decide the appeal, I will
My lord,
consider that it is
my lord,
dismissed.
kindly, my lord, the reason is, my lord, the observation of the, my lord, the tribunal is, my lord, very specific.
All right, let him take instructions. Monday, I think corporation will not go to demolish. Is it, you will demolish in Monday? I am giving, sir, I am giving you liberty, demolish on Monday.
That is notice.
No, will you be able to demolish on Monday? I am asking you.
My officer told me that is 24th July, but here the 21st is July. So
That is why I am asking you. Can you implement on 21st of July?
how can I say? Because I now within 3 minutes I receive. That's why I stayed the order. I will come back with her. And then we should have to.
Well, let the matter, my lord, remain in its position, my lord. Otherwise, my lord, the difficulty will
The learned advocate appeal for the
This is with respect to Lordship, a section 5 application which has been allowed in connection with a miscase for.
Not today, my lord. May I prefer not today, my lord.
don't prefer not to pay, accepting not to pay for anything. Yes.
When a section 5 application, Lordship, has been allowed, the section 5 was in connection with the restoration application of a suit filed by the plaintiff. The
the grounds in the section 5 application and this miscase, Lordship, they are exactly same, which is the fault of the learned advocate. Lordship, in reply, I have said that irrespective of the fault of the learned advocate, the client had noticed that the suit has been dismissed.
What is the period of
On the
delay?
basis,
What is the period of delay?
43 days delay. Lordship, why we are before Lordship? Because by allowing it, the section 5 application, virtually my defense with respect to the miscase completely gone.
Why?
Because, my lord, the grounds are absolutely same. It is the advocate's ground which has been taken. But, my lord, my ground with respect to which that they had noticed that the suit has been dismissed, we had given them separate notices by check, and Lordship, there are other documents where we had given them money order. Twice we had given them checks. Once we had given them money order, we are depositing in the rent control. Lordship, they all had noticed. So the plaintiff had noticed that the suit was dismissed. Maybe it was the advocate's fault. Assuming, but under the plaintiff.
What is the suit for?
Suit is for eviction.
So suit for eviction, dismiss for default, fresh suit also can be filed.
Fresh suit can be filed.
So why?
Lordship, then my lord, if Lordship is inclined to allow it.
Yes.
Lordship, my Lordship will kindly protect me.
Yes, yes.
With respect to my defense to the
Yes,
miscase.
yes. That I will protect.
Why, my lord? There are two.
Also will protect. So merely because section 5 has been allowed, that cannot be mechanically allowed. That I will protect.
And my lord, my Lordship, I said that I shall be allowed to lead evidence to prove my case that the plaintiff had noticed.
Has to be.
Section 5 that has been
miscellaneous case has to be proved by evidence. Has to be.
Absolutely. That blood, in section 5 also we wanted to lead evidence, my lord. That has been the court said that I shall consider.
Section
and
5
when the consideration
Section 5 is decided on affidavits. Now what happens, unless the Section 5 is allowed, cannot enter into the miscellaneous case. That's the difficulty.
Kindly then protects.
Yes, yes, that I will. This application under Article 227 of the Constitution in the civil litigation.
And the cost I will pay.
The petitioner is time to
It's exactly the same.
Same.
Only the suit number is 310.
পরেরটা সেম শুধু ওই সুট নাম্বার
Number is different.
Yes, thank you.
Suit number is 310 of 2011 and Miss case number is 58 of 2023.
Yes, call the next matter.
Item number 26.
In this matter, Lordship, Mr. Dolapati is appearing, my lord. He is engaged in code number 2, my lord. A short possible, Lordship. This matter is going on. Code number 2, Lordship. I am not doing this matter, Lordship. Kindly short passover is coming. Passover. Next.
Item number 27.
Your Lordship, I appear on behalf of the petitioners. The matter has become infructuous as the learned.
That matter, there was some dispute. SD was appearing before the appeal unauthorized occupant. There were certain
This
allegations.
is what happened.
My lord, it has remanded back to the SDO.
So now it has been.
This is the order, my lord. Kindly keep this on record. Last. The order, my lord, the last order is dated.
Learned, Mr. Tonoy Chakraborty, learned advocate,
Petitioner, my lord. I am for the petitioner. I pray for short pass order. This Noel Banner is appearing.
Why are you not serving copies?
Okay, my lord.
Please serve a copy.
Okay.
The learned advocate appearing for the petitioner.
Well, 29, my lord, I made my submission. Well, refusal, my lord, to reject refusal to reject the plaint or return the plaint. Order 7, Rule 11, my lord, we made an application. I had argued
Oh,
my lord,
Julian Finance.
forum. Yes.
Oh, I have not seen the cost at least.
No, not that. That, my lord, has put it in August. The other one. This is, my lord, the JM Financial.
Yes, yes.
I think Mr.
Oh, this is with regard to
the forum selection clause, my lord, exclusive
yes,
forum selection
where it
clause.
should be land, whether it's a suit for land or
Correct. Absolutely. It's a cancellation of an assignment agreement.
yes, Mr. Ghosh. What will happen to that? You are looking behind.
I am looking at 3 o'clock, my lord. I will again be half cooked, my lord. Again I go back.
Half cooked.
Yes, my lord.
That is not a good state to be in. Should be either fully cooked or no.
I said, with 90
Why? How much time it will take?
I just started, my lord. Anytime.
Shesh karo, sorry, shesh.
If lordship wants to.
Yes.
And rest part, my lord, friend has a target. He has other points.
Yes,
Got me on the suit for
that's
land.
right. Suit for land.
He says that it's not maintainable before that court. He was gone on that.
That's all. Only that one. I had placed the claim. That the claim lordship takes.
I think you wanted to cite a decision.
I wanted to find
Yes.
lordship not takes the claim from
Page.
page 131. Page 131. The claim starts. The schedule of the claim is at page 158, which is in the second course. I remember that.
Yes.
And the claim pillar is the claim. The schedule of
Can it not be done in one volume?
The last time also, my lord, I think, my lord, the direction or my lord, thing it has to be 150 pages. Every volume.
No, 150 pages, you can do it in one volume a bit less because 20 pages, I don't know, because a document is being bifurcated. It's
But my lord, the rules say, my lord, 150. I think, my lord, that's
you
what.
cannot do, make it less also. You have to make it 150.
Up to 150.
No, up to is.
I'm
So
not
you
very
can
sure,
make
my
it
lord,
130 or so in one volume.
I think, my lord, says each, if I remember, each volume to contain 150 pages or something like that. Or should not be more than 150 or something like that. My lord is correct. One can be less and.
Yes, because this
Just
creates
remember the next.
difficulty because at times.
That's the direction, practice direction, the lordship has to modify by way of practice.
No, but Dr. Kitability check. Well, that's a solution. That's a solution. What fell from my law?
Yes, because at times
if the document is going to become half, yes. So therefore, what you can do is you can reduce. And I couldn't take it. You can
yes,
reduce
Mr.
it.
Ghosh, like in the other matter, please do that. Only plain, no annexures. Please give me yes. Now you can proceed.
Now let us take the place.
Because I think that's the better way. Only the plain. Give me only without the annexures.
Yes, it helps.
Helps.
The lordship takes the lord. What is my claim in this? The claim is degree.
You want me to go to which page?
It's there, lordship will find.
Prayers 157.
153 is the prayers. Lordship will take the prayer A. The degree of specific performance of the agreement dated 15th January 2020. Paragraph 27 above, perpetual injunction restricting number 1, and on its rent servants and anyone claiming or other from acting in breach of the covenant containing paragraph 25
Then perpetual injunction, anyone claiming excess. So these are my clearing the claim and delivery of and cancellation of the termination notices at page 155 and at page 155 the delivery upon cancellation of the 2nd March 2020 by the defendant. Then declaration that the defendant 2nd March 2020 issued the defendant purporting to exercise the option to forfeit the money in terms of the said agreement by the defendant is inoperative. Now with that kindly to the text will not there G. That
Yes.
page 156. For perpetual injunction, basically the defendants are the employees of anyone claiming to the defendant number 1 from saving and transferring on somebody otherwise party to possession of the suit property or interest in favor of any third party, any kind of party. Now, with H, final prayer a decree for mandating directly the defendant number 1 to register the deed of assignment of the charge of the financial assets set out in Schedule 1 of the agreement dated such and such, including the property more fully described in Schedule Z, the fixed assets plan set out in Schedule of the agreement in terms of the paragraph 27. So, whether removable property. Lordship goes by the claim, nothing but the claim. The agreement annexed to the immovable property. If Lordship Willard takes the agreement annexed to the immovable property, Willard is the definition of financial assets. That is, there Willard setting what is the financial assets, Schedule 1 and Schedule 2. These are the financial assets in question.
Properties.
Those are Willard's fixed charge on plant and machinery as well as the property in question. That's the financial assets.
Plant and machinery is on that immovable property.
Property itself. However,
Which according to you falls within the jurisdiction of the Howrah court.
There's no dispute. We are not. There is a forum selection clause in the agreement says that it will be moved by. So will that be operative? Will that not be operative? Your Lordship is kind enough to take the agreement to assign. Second part I come with the right up. That's at page 44.
Only 44.
Page 40. First one.
Yes.
That agreement for assignment, gain financial asset reconstruction company, the assignor, and starts at page 44 and 46. Abhinandan holding private limited assignee, page 46.
Yes.
Financial assets, fine. Give me the fine. What is the financial asset? That's defined in 1B.
I've got.
46.
Yes.
Financial assets means from the bank and now from the assignment and all amounts assignments by the borrower care of and all other money whatsoever by the borrower to the intended assignment thereof together stated. Now kindly take the schedule in question. I am only on that for the bank. Lordship will take the governing law, page 49, clause 7.2. This agreement shall be governed by and constituted according to the law of India. Any dispute pursuant to and out of this agreement shall be submitted to the execution of the member. Now kindly look to that. What is the Schedule 1? Schedule 1 has been the page 5 to 50. Paripasu Schedule 1 working capital loan, Paripasu hypothecation charge on both of the current assets of the borrower, namely stocks of raw materials, stocks in process, finished goods, spares not relating to plant and machinery, consumable, receivable, good debts, and all other receivable both present and future, whether now lying in those cases which are now lying or after compensation, got upon or stored into the borrower's factory premises, godowns, including Howrah, wherever else the same may be held by or any part, deposition of the borrower of transit. However, whatsoever in possession of the I will substitute other one. Now with the collateral. Collateral security working capital pari passu charge along with State Bank of India. On the fixed assets of the company, all the pieces and parcels of the land.
This is the immovable property.
Now, my lord, my claim says so. If my claim says it's a suit for land, my lord, my claim has to be proceeded that the contents are true and correct. And my lord, is absolutely correct. Financial documents, there is separate schedule that will not pay. So far as
Page.
Financial assets is page 52. Financial documents is at page 50. Financial assets, page 50, property, the subject matter of the suit is page 50. Financial documents, whatever I have explained. So these are the two separate things. Now, if your lordship can claim the
And suit is with regard to financial assets.
financial assets, that's one B of the document in question. It's part of my claim, and my claim has requisite feelings in relation thereto. Then I straight away come to the judgment in question. If the claim itself, if the lordship takes the claim itself, then will not the second column, the paragraphs lordship takes, only lordship marks it, lordship marks it, para 43 of this thing. Para 43, or will not lordship can read with us from para 40 on. 40, 41, and 43. Specific case takes 43 on. Inasmuch the immovable property being the subject matter of the present suit forms the financial assets. There is no mistake. The charge in relation whereof assigned in favor of the plaintiff by the defendant is situated at such and such house within the jurisdiction of the Penal Commerce by reason of this court has jurisdiction under the C1 of the Commercial Codes Act. Now, this is what I have stated. Now, if I have stated so, then it has to be processed for the order 7 to 11 purpose as to an citing whatever other documents is not necessary. Now, what is the effect? The judgment shown by my learned friend is starts, there is no dispute with the proposition. It flows from Hakam Singh's case, ABC Laminat, then Swastik class. But those are the cases of contract, supply of goods. It's not a case of immovable property. Now, what is the position in respect of a suit which concerns an immovable property? Lordship, now I go to the judgment straight. Now, kindly have a look at the judgments in question. Takes 2005 7 SCC
791.
791.
You have given a copy.
I given a copy for my lord so that my lord can.
Yes. But yes.
Kindly have a look at
Which are the paragraphs you will be relying upon?
16 to 20. First lordship takes
16 to 20.
Paragraph. Let us start with 16. So that we had a forum selection clause. Kindly have a look at the paragraph 16. Or whether I based on paragraph. Kindly whether takes the para 14. There the forum selection clause is
Paragraph
14. 14. Having regard to the counsel for the parties and having considered the resolution of the court as to the direction cited, as to the decision cited before us, in our opinion, the order passed by the trial court confirmed by the High Court as the admitted fact relates to recovery of a property of Lord admitted such and such residential colony of it is not in dispute by the parties to the property. It is no doubt that having the head office in that the agreement was entered by the parties in their. It also cannot be denied to the was made at PE and same installments were made at PE. It is pertinent medical question, however, is which court is the paragraph 50. Now this section 50 pages of the code contain detailed provision relating to the jurisdiction of the court. They regulate the forum for institution of dispute. They deal with the matter in domestic concern or provide the magnitude of which can be brought into the court. Section 15 requires the suitor to receive dispute in the court of the district company's rights. Section 16 allows the suit for recovery of property for partition of input property or for foreclosure and mortgage or for determination of the right of interest in input property or for compensation of money for input property shall be instituted or within local limits of property situation. The provision to section 16 declares where the relief sought can be obtained in the personal resolution of the court suit can be instituted either in the court property situated or in court resides or carries on business or personal gain. Section 17 supplements section 16, which is virtually another device to that section. This is where the property is situated. Section 18 applies for the local limits of jurisdiction of different courts and uncertain. Section 19 is a special provision. Provision applies to sue as a compensation for wrong for personal property. Section 20 is a specific provision and covers all cases not covered by section 19. Section 616 does recognize the well-established principle that action against waste of property should be brought in the forum with the rest is situated. A court within which property is not situated has no power to deal with and decide on interest of such property. In other words, the court has no jurisdiction over a dispute which cannot be an effective judgment. The provision to section 16 states that though the court cannot, in case of input property situated beyond the control class, between and and be obtained from personal private person. The provision is based on a well-known of maximum person is recognized by chancery. Then the court of jurisdiction maintains certain suit of input property situated beyond personal disobedience. The principle in which maximum is done. In a suit of input property situated abroad by enforcing judgments by in process of personal arrest by attachment of the judgment. Nominal paragraph 17 is quoted. Nominal I just listen. In such and such the court of equity are always been in exercise of one operating personal and not in trade and exercise of the personal jurisdiction. They have always been performance of the contract of the class subject to the other activities. Rational officer they have done so as far as lands is concerned. The proviso is thus an exception to the main section, which is not considered opinion, cannot be constituted, thus the scope of the principal provision. To apply only if the suit falls within the category specified in the main part of the section, and the reliefs not entirely dependent on personal details of the next. In the instant case, the proviso has no application. Sought by the plaintiff or specific purpose of the state of the property director, the extreme in favor of the given condition to be. The trial court has provided the first property in our opinion, submission of the counsel for the appellate that the parties have agreed that the court and jurisdiction of the matter arising of the transaction has no force. Such provision will apply to cases like and the parties agree. Now, we have straight away come without para 13, accounting. Para 23.
Yes.
But the question came up for consideration of this court in accounting gamma, which was first taking decision on the point. There was a contract between the parties for construction of the work. An agreement provides a notwithstanding what the work was to be executed. The contract shall be deemed to have been executed at Bombay. The Bombay court alone has jurisdiction to adjudicate disputes with the parties that question there before. This court was whether the court has Bombay alone has jurisdiction. Upholding the constitution of the contract, the court says that our Mr. Banerjee has already placed it for the other judgment. I do not place that on logical standing. Take paragraph 16 or 25. Everything is quoted.
Yes.
Everything was cited. All the judgments have been quoted. Now 26. Because my learned friend has cited Mr. Hakam Singh, my learned friend has cited as ABC Laminat. There are other judgments which are put in. The question, however, is whether this matter. If the answer to that question is that affirmative, the contention of the case must be upheld since the report has also jurisdiction to entertain the suit. And the parties and agreement are submitted to the jurisdiction of that court. The case is covered by section 20, and in view of the choice of the court, the plaintiff can be compelled to approach that court as per the court. If on the other hand the contention of the case is accepted, it is held the case is covered by section 60. It provides in section 60 as not as applicable, nor section 20. A residual clause in the court has not been. The order into cannot be said to be contrary as the in the court question covered by the part of section 60, neither the provision section nor section 20 should apply where Delhi court lacks inherent jurisdiction to deal the court. Now we got 27. The High Court considered the submission of the claim that the Delhi court has jurisdiction negatively. The court, after referring to the various cited at the bar, concluded from the aforesaid principles laid down by the Supreme Court is abundantly clear when the parties to the contract agreeing to vest a jurisdiction to a particular court, cause of action has alleged particular claim cannot be said to be void against the public policy. It was also made clear in the said decision, however, a particular court does not have jurisdiction to treat the subject matter.
Because consent cannot confer jurisdiction. Consent cannot confer jurisdiction.
This is Supreme Court we are asking. Now that have a look at just what you permits that paragraph 34.
Yes.
There is a Delhi High Court judgment, also division bench shall cite after that. The case on hand relates to specific performance of a contract and possession of a immovable property. This is my claim. It may be a bad claim, it may not be a good claim, but this is my claim. One has to proceed.
You may not after all succeed.
I may fail, but this is my claim. This is how I frame the cause of action. On looking at the subject, on looking Millard, or the form of code of civil. Lordship knows Millard appendix 4 Millard form number 16 Millard. That's on the back side of civil. Now Millard, the case on hand relates to a specific performance of a contract in possession of immovable property. Section 16 deals with such cases and jurisdiction of competent courts where such suits can be instituted. Under the section condition, a suit can be instituted where the property is situated. No court other than the court where the property is situated can undertake such suit. Hence, even if it is an agreement between the parties to the contract, it has no effect and cannot be. That's by pleading. Now we are reading. Now we are trying to have a High Court judgment. That
Thank you.
this is 2009 10 volume 107 Delhi Law Journal 28 division. Suits for specific performance.
Which paragraphs?
You are kindly have a look at paragraphs. And ADCON is quoted in paragraph 9 of the judgment, which is page 31. Now we are trying to have a look at the judgment is quoted. Now, which we always cite, that is also quoted. Paragraph 9 দেখালাম স্যার 9 আর বুঝছি না just if you got this paragraph 10 of the judgment, this is paragraph page 130.
Yes.
The court further observed that though a suit for specific performance of contract contains a stipulation on execution of safety condition of the and because it is implied for the position as a part of the having regard to the provision of section 6, but unless the relief of policy is specific and granted, the discussion on this aspect of paragraph 7 of the statute, it has to be seen subsection 1 is an enabling provision. Updating the suit for specific purpose, we ask for further information clause A and clause B thereof. Clause C contains certain brief of partition in separate provisions of the property in addition to specific purpose. The mandate of subsection 2 of section 20 is that no relief under clause A and clause B of subsection 1 shall be granted by the court. Thus, it follows no court can grant a relief for partition or other property of the agreement for sale of land in specific purpose. The partition was specifically paid for. On this basis, court held and before it the relief of partition was not besides not the land. The Bombay High Court had the jurisdiction to implement the other action of the court file on for like sections of the application of section 50 of the code accepted for the execution of right. So it's a frame of with a specific performance, you can frame it under section 20. Don't make a schedule of the invoice property. Then you schedule the agreement. So if you want to make it a suit under section 16, then you have to frame it accordingly. Now the kindly lot takes the paragraph 21 to lot.
Yes.
Paragraph. Lordship just para 16 if the lordship is at page 125, where section 16 the definition of section the provision does an exception that weight versus weight, that's the 35. Then we got just paragraph 74. In the extent case the provision has no application, the relief sought by the witnesses for specific performance respect of the input property by direct is said in favor of the position of it. So Alford was therefore right holding that the suit was covered by clause B of section and the provision has no application. In our considered opinion, submission of the learned counsel for the appellate parties that finally comes after the quotation following the Supreme Court, because the Delhi High Court judgment has been quoted. Say, don't please, Providal is quoted, the another division bench at page 236. Lordship just make a note of it.
236.
Yes. Then Lordship straight away comes to paragraph 20, which Lordship takes paragraph 20 at page 139.
Yes.
Again, as mentioned by such and such, who appeared for the claim, agreed with the proposition of law. The submission, however, was that in the instant case the plaintiff has not sought a relief for recovery of position of premises is subject matter of agreement. The such and such learned senior and counsel appearing for the defendant on the other hand argued to the contrary. Therefore, the real controversy is whether the plaintiff's claim position has been. The controversy is arising because by the reason the clause does not specifically contain a position. At the same time, the plaintiff has appealed all consequential reliefs in the following manner: pass a decree for mandatory injunction against the defendant jointly and separately, as per the draft statement on such and such, and take all counsel allowing the perform the rights of the with the agreement such and such. The first relief is for mandatory injunctions in direction of the execute the leasing. This is in nature of specific performance. We are concerned with the second part, the right whereby mandatory injunction is sought for direction or consequently allowing for perform the rights and obligations of the state. As well as I have asked for the directing without execution. Kindly take paragraph 27 what you I am not reading. We are therefore of the opinion that the prayer clause as it stands, a decree for possession was paid for in form of consequential relief. In such a situation, 16B of the court with a clear application of the facts of the case and the learned single judge rightly held that the Delhi court has no jurisdiction to entertain this. Therefore, have no option but to affirm the order of the learned single judge.
Yes.
So, how it's a question of frame of suit. So, if my frame of suit is taken for order 7 rule 11, it's a case falling in the section 16 and not under section. In fact, I would have read paragraph 18 now on the question of assignment. I believe because my learned friend has taken the point of assignment also. I want to put in. Because if your lordship takes these two judges, gives my plate side by side. Lordship looks at G, lordship looks at H, where G and where H. And there is a schedule of immovable property there. And
Yes.
the document speaks of financial assets. So what more I need to do by that mode of I think that this is a solution. On assignment, my little friend has made a submission, but if lordship wants me to answer, now I'll answer, but after lordship decides this.
Can I answer, my lord, or my lord, I can come back, whatever my lord wants. I don't know how these judgments are relevant, but I'll just show that, my lord.
Yes. What are the other points, Mr. Banerjee?
May I just answer on this? On this also, I think my learned friend, my lord, should actually, my lord,
yes.
My lord, kindly look at, my lord, his, my lord, let us, my lord, understand what the law is on this. Section 16 to 20, if it's a case under section 16, then a forum selection clause is irrelevant. There's no dispute about that. If it is not a suit for the purpose of specific performance and delivery of possession, then it is not a case under section 16. That is the law, and that's what my learned friends' cases also show. I'll show, my lord, all these paragraphs, my lord, they're all. I'll read, my lord, his paragraphs once more so that, my lord, that is, my lord, also there. All those cases, both these cases, my lord, say it has to come under section 16, which means suit for specific performance and delivery of possession of immovable property. And, my lord, the first case, Supreme Court also says any decree which is possible by personal obedience of the defendant is not a suit for land. If my lord wants to look at, my lord, kindly look at, my lord, my learned friend's judgment, 2005-7 Supreme Court cases, paragraph, my lord, 19. Sorry, my lord, before that, kindly look at, my lord, paragraph 16.
Paragraph 19 is clear.
Clear. Before that,
Says to
16.
execute and to deliver possession.
Yes. And, my lord, the top also, my lord, sees kindly at the top of, my lord, which is paragraph 16 carried over. In other words, the court has no jurisdiction dispute which cannot give an effective judgment. Proviso to section 16 no doubt states that though the court cannot, in case of improperty situated beyond the jurisdiction, grant a relief in rem, still it can entertain a suit where relief sought can be obtained through, let's see, fifth line.
Yes.
Personal obedience of the defendant. Now, my lord, this agreement, my lord, I can come back, my lord, if my lord has, my lord,
want to come back?
I think, my lord, I'll need, my lord, 15-20 minutes, my lord, just, my lord, to. Because I think, my lord, it's clearly, my lord, a suit, my lord, which has to go. So, my lord,
All right.
just kindly give me that 15-20 minutes, my lord, on the question of, my lord, this first point, my lord, which has to be answered.
And what are the other points, Mr. Banerjee?
My lord, there was one point, my lord, with regard to, my lord, revocation, recall of, my lord, section 12A, leave of, my lord, that, my lord, Patil is.
Let him argue whatever he has. I have made this.
No, my lord, I want to argue on this first point, and I think, my lord, I'll try and, my lord, pursue my lord on the first point itself. It is very clear. I'm very.
The other points you don't want to argue.
12A. No, my lord, I first, because otherwise, if there's no jurisdiction, there's no jurisdiction. Section 12A, my lord, is to submit to jurisdiction, and the other one is, my lord, not disclose any cause of action.
Section 12A will be your other matter also.
Yes, and section will not consequential.
12A and, my lord, no cause of action, that also I'll show. My lord, that suit will be dismissed. Because, my lord, some judgments, my lord, which I have, but provided, my lord, there is jurisdiction, my lord, to entertain this.
Now, my lord, Excel DLCOM is clear. You have to go and if you ask for execution of a conveyance, it's a suit for that. That's Excel DLCOM.
Not really.
It's Excel, it's a Supreme Court.
Not really, my lord. Conveyance is different. What we are looking at, my lord, is an agreement to assign.
Hard mis-
I'm grateful. I'm grateful.
Only one thing, my lord, I just forgot. I can let him also distinguish the Excel DLCOM.
Excel DLCOM, I'll distinguish that.
Item number 21
without express prayer for demolition.
What the paragraph was? Take it.
Without express prayer.
Yes.
Consider also Excel DLCOM 1015 ASC, page 29. What should we consider?
Mr. Ghosh, you can formally cite that on the next day. Which paragraph?
16 to 13 to 17.
Paragraph 13 to 17.
There was what Mr. Banerjee was saying. It was going from this court. There was
I'm aware of it. I'm aware.
He must.
I'll deal with it.
Look, you know this subject better than me.
Yes, who is appearing?
21 is my application, my lord.
Yes.
Mentioned today. My lord, the order under challenge, impugned order, my lord, they filed a contempt application, which is why the urgency, my lord.
Yes.
Lord, you will kindly take up the impugned order once. Lord, she was in fact hearing this matter on the previous day. There was a report that was prepared, my lord, by the psychiatrist for the child. This is in relation to a custody battle, my lord, under the Guardians and What's That filed by the opposite party. I'll just quickly indicate whatever the background facts is. I filed an application. I'm the grandparent of the child. The mother is no more. The child has been with me for the last 5-7 years. The child's been with me. Now, there are several rounds of litigation that have happened prior thereto. In fact, there is a memorandum of understanding also, my lord, arrived at by and between my clients, the grandparents, and the father. I filed a 710 application saying that this proceeding cannot happen here. The child is, my lord, ordinarily residing in Maharashtra. My lord, that is pending. There's a civil revision that was not allowed. I have filed a civil revision application that is also there, my lord. Subsequently, with respect to visitation right, my lord, there was an application taken out by the father, which is the opposite party here, my lord. In that application, visitation was, my lord, originally allowed. I challenged that. Once I challenge that, I come before a coordinate bench of this court, wherein, my lord, the honorable judge says that considering the situation of the child is not of a tender age, not in the mental condition, my lord, to meet somebody new because he's not been with the father in the last 5 years. In that scenario, the coordinate bench, my lord, came up with a system. He said, you produced the child and you mandated. I didn't want to produce the child. I'll be very candid. He said, no, you have to produce the child. You bring the child down to Calcutta. You produce the child in the chamber of the judge before the, my lord, district judge, my lord. And once you put the child without the father, just with the grandparents, once without the grandparents, just with the father, and also independently without either of the parties, just with the judge. And then you ascertain the mental condition, the psyche of the child. My lord, based on that, once we go back before the court, that entire exercise is carried out. The judge, my lord, returns a finding on that day that because of the mental condition of the child. At this juncture, it cannot be ascertained whether or not the child can be, my lord, given to the father, or can any visitation can be permitted or not permitted. So therefore, the judge says that you put the child, my lord, for immediate, my lord, psychiatric, my lord, assessment, not for any treatment, psychiatric assessment. Let the child go to a psychiatrist in Pune itself. Let the child go to the psychiatrist. Let the psychiatrist, my lord, return a report. And based on the report you file before me, I will take a call whether as to the child, my lord, can be the visitation of the father at this juncture, can be permitted or not permitted. That was the direction. Now, pursuant to that order, fresh, my lord, psychiatric, my lord, assessment starts. I take the child on all occasions. I have, my lord, brought my all the evidence with respect to, my lord, the inpatient meeting. All of that's in my civil, the tickets, my lord, that you are taking the child. All of that's a part of the record. I take the child. The assessment is completed. There is a report, my lord, the child gives prior to the next date of hearing in a closed sealed envelope, which is given to me for that to be handed over to the court. In fact, I'm carrying that. Due to, my lord, some confusion with respect to the advocate who was conducting the matter, but she was, my lord, she's in postnatal care right now. She recently delivered. She couldn't go. Now, the junior who was sent in the matter, my lord, she unfortunately, my lord, wrongly, she files a time petition before the lower court, which also we annexed, my lord, we've not suppressed anything. Files a time petition saying that, my lord, the report has not come because that was the only thing she could find from the previous order. So she could not, my lord, she says that the report is not there. In fact, the report was already given to. I do not know what is inside the report, and files that time petition. The judge in the court below, my lord, says that in fact, I have not taken the child to the psychiatrist, which is why the report could not be filed, even though the report is otherwise there. And therefore, on the basis of that time petition, the judge, my lord, passes an order saying that the father will immediately go to Maharashtra, not in the same city where the child is, in a different city, in an unbiased city, my lord, if I can say so. And then says that on alternate weekends, the child, my lord, has to be produced with the father. The male member of the family is to accompany the child. The father is to book, my lord, a resort, whatever resort is available in that city. And then the child is to be produced for a period of 48 hours. Uninterrupted, my lord, visitation right. Now, my challenge against that order, I've immediately filed a civil liberation application, which is pending before your lordship. My challenge is on a very close, my lord, ground. My challenge is not with respect to the father having a visitation right. I am not challenging that at all. My challenge is twofold. Number one, that the order which is under challenge, the impugned order, that is directly contrary to the previous order passed by the judge. So even if I take my fault into account, that the time petition was on the basis of certain wrong facts, even then that 1 day's accommodation could have been granted so that the report could come in. Because the judge, which is, my lord, the immediately preceding page, my lord, before the impugned order, page, my lord, 115, lordship, before looking at the impugned order, my lord, will kindly look at 115 once, my lord, annexure S. I am saying that this is a contradictory order. So once the judge holds that this psychological assessment is necessary prior to passing of directions for visitation, and a report was called for, without that report being placed before the court, the order of visitation could not have been granted. I am saying if the report says that the child is capable of visitation, you allow the father. I will not stand in the way of that. He is a biological father, he has the right. I am not, even as an advocate, I cannot come and say that a biological father will not have the right to meet the child. But if the judge is held pursuant to an order passed by this court, that the assessment, let their assessment happen, unless and until their assessment is apprised of before the court, assessed, taken into account, this order, my lord, could not have possibly, in my respectful submission, been passed. But I'll be very candid on a completely different independent point, my lord. I am led by Mr. Shuddhashatta Banerjee. He's on his way. Before my learned senior friend takes over, my lord, lordship will kindly, my lord, hear me till he comes. For just 2 minutes.
May I address your lordship? Mr. Banerjee will come and, my lord, revise
this.
Lord, kindly have a look at the list of dates, my lord, I have prepared. Lord, this is only to assess the court. The only question that remains, my lord, once a party to a lease has given consent to an order being passed in their presence, and thereafter has acted in terms of that order, whether that order can be at all challenged or not. That is the first question that is to be.
This order, they have accepted.
They have accepted. I'll show, my lord, kindly takes up the list of dates. List of dates, my lord, kindly goes to, my lord, the annexure C, that is the correspondences. I'll also place the order, because when this order was passed, they did not object to the visitation, they did not object to the place of visitation. That is very important. And that conduct, my lord, would appear from the email correspondences. My lord, kindly have a look at page 26 onwards. My lord, that's the email.
26.
Page 26, my lord,
Of this
list of dates. Yes, my lord. Annexure C.
Have
my
you
lord.
given him a copy?
Just given him a copy.
He's had it.
Yes.
My lord, kindly sees, my lord, the correspondences. My lord, we write to them. My lord, the judge says that second week of every month, 48 hours uninterrupted visitation.
Schedule.
Now, my lord, on one pretext or the other,
Not false at all. My lord, exams were going on. I have the timetable of the child
this was
also.
never there, my lord.
I have the
my lord,
timetable. He
my lord,
goes to the
my lord, let me finish.
I'm,
that
I'm
first,
sorry.
my lord.
I'm sorry. I'm sorry.
My lord, they cannot have best of everything,
No,
my
I'm
lord.
sorry. I'm sorry. I
I
apologize.
have agreed to the jurisdiction being Pune. Mumbai, not Pune. Your lordship knows what is the precedence, my lord. If I go to Pune, my lord, number of criminal cases has been lodged against me. So I cannot go there. So I agree to Mumbai. I did not even say that child should come here, because child's paramount welfare is of the consideration. They agree to that in open court. Now, my lord, I do not find any contradiction in the order. I'll show to your lordship. My lord, child's mental assessment has got nothing to do with a child meeting his father. And I'll also show that portion that the child's mind has been corrupted by the grandparents.
Yes.
Simplicity of what I am seeking. My lord, kindly sees the correspondences. What does it say? They say that I am informing you, I am informing you. That means, my lord, they have agreed. They have never said that no, we are not agreeable or we have challenged this order.
Order was subsisting. If you take, if
They have
you
never
say-
challenged.
Give
They have
me a
never
minute.
challenged
Give
the
me a
order
minute.
sorry.
at that point of time. So all along.
Give me a minute.
Kindly have a look at page 28, my lord, second line, which would, my lord, rest the entire issue. I am the sole conducting lawyer. It starts.
Yes, yes, please give me a minute. Let
Yes,
me
I'm sorry, my lord, I'm sorry.
Yes.
As your lordship found, my lord,
Yes.
they have themselves agreed, my lord, they want to execute the order. Dates were also fixed. Now, my lord, they come up with this stand, and now, my lord, they say that, and I'll also show the order of the, my lord, the trial court. It is not in contradiction. I'll just show two lines, my lord, which says the last part of the order. If your lordship kindly takes up the impugned order, Lord, the learned judge has taken into consideration everything. Kindly have a look at the, my lord, second page, internal second page of the impugned order.
Yes.
Last paragraphs, my lord. Continuing the right of visitation of the petitioner, the evaluation of the mental health of the child by the clinical child psychologist to be continued, and a quarterly report of a clinical psychologist must compulsorily be received by this court on the date so fixed for this purpose. So it has not been given away. Father meeting a child cannot stand in a way of a mental evolution of a child. That is on a different aspect altogether. And they agree to implement the order. Now, my lord, they come and approve it and reprove it. How is this possible?
May I respond, my lord? I did not want to take this point, but even otherwise, this order, my lord, is a cyclo-styled unreasoned order. My submissions have not been recorded. It only says heard the submission of the.
Then do one thing. You withdraw this application, file an application there.
I'll not be able to do that, my lord.
Why?
Because I'll still be
No, according to you, on that date, you could not produce that medical certificate
Yes,
of.
I have that.
No. That is, so it was with the learned junior advocate, he or she could not place it before the court, as a result of which this order has been passed. That's your submission. And
a part of it.
yes, part of it. And it is your apprehension that if that is produced, court could have seen that this order could not have been passed. That's also one part of the.
I do not know what's there in the letter.
No. If you could have produced, because your apprehension is that because of non-compliance of the order, perhaps the learned trial judge has passed this order.
Yes, that's only.
Yes. So that's your apprehension. So why don't you go back? Why don't you go back to the learned trial judge and say, explain your conduct, why you could not produce this, and pray for recalling of that order.
I'll indicate.
Withdraw this.
Feedback. I will indicate why, my lord. I'll just take, my lord, 2 minutes.
It's the difficulty because that's your only grievance. And you are saying that you do not have any objection with regard to the visitation. You want that report to be placed. The court will consider. So do that, withdraw this, file an application for recalling there.
May I just make one last submission? I'll make one submission. But I understand that under 227, superintendent power, the scope is very limited. Today, I will have to show, this is not a reappraisal of evidence. Today, all that I'm required to show that the order that has been passed was so unreasoned and perverse that no person of ordinary prudence could have arrived at that. That is all that I'm playing with right now. Well, today, even.
What's the perversity?
The perversity.
A father has been allowed to meet the child.
Yes,
what's the perversity in that?
I'll dislodge you. Bears with me for 30 seconds. Yes. Bears with 30 seconds. Well, I am saying this, that today, if let us assume that there was no confusion, or there is a confusion, this report was already there, the report could have been brought. If the report was brought, then the result could have been different. But my essential argument is this, that today, even if say, for example, I had delayed, I did not take the child there, or I took this order and I tore it and I did not produce it before the authority, or I opened this, I'm taking it upon myself as an advocate. I've done that. Let us presume the worst case scenario possible. I have done that. My objection with respect to unreasonableness and perversity is that even in that scenario, this order could not have been passed, because the order immediately prior to that, Lordship will take a 116 once. The court says that, Lordship will look at 116 once.
Yes.
I'm sorry, 115, the last part of the last paragraph.
Yes.
I'll read from the last part. In course of, Lordship is at 115.
115.
115.
Yes,
in course of long interaction with the child in my chamber, I have talked with him on several matters which I don't find fit proper to discuss it in my order. But in course of my interaction with the child, this learned court had a feeling in the mind that the mind of the minor has been filled with negativity regarding the petitioner's parents. This is absolutely uncalled for, unwarranted. No evidence to lead this. But I'm not challenging that. The petitioner is the biological father of the minor and the natural guardian, and the minor is living separately for him for the last 5 years with his maternal grandparents, and maybe at that his mind has been influenced by his maternal grandparents. These should be expunged, but that's for a different day. And in this stage of negativity in his mind, I don't find it will be proper to allow any visitation right to the petitioner, as it will have a negative impact in his mind and psychology. And when children are adamant at a time not to meet the other parents who does not have custody access to meet the child, the assessment counseling session by a child counselor play an important role. And a counseling session evaluation by child psychologist prior to exercise of visitation rights can play an important role to make the visitation right meaningful and also remove apprehension, doubts, if any, in the mind of the child. In such a situation, clinical child psychologist will be in a better position to provide the counseling session to the minor, and the report submitted by the clinical child psychologist on evaluation counseling can be shared with this court in a sealed cover, which would enable the court to form an appropriate opinion for custody visitation right in this case. So he considers the report as a prerequisite for arriving at that finding.
Yes, that is why I said So the earlier order, the court felt that this report is necessary. So directed that the child should meet a child psychologist. He or she will examine and submit a report before the court. So according to you, pursuant to this order, you took the child to the child psychologist. Child was examined by the child psychologist, and he has given a report in a sealed cover. So that report was given to you for being produced before the learned trial judge. For ABC reasons, that was not before the court. And the court, after finding that there is no report, I think drew some adverse inference against you and passed this order. So best thing is that you approach the court, tell, yes, this was examined, this is the report, please consider that. And
file a recalling application.
Yes.
For example, the difficulty will be the time petition that I filed, the court will use that against me. Lordship has ample powers under superintendent.
I cannot recall on that ground. Why did you file that time petition? Explain everything. Explain everything there, file that application and produce it, because that court directed that. It's
And
not
the
the
time
court.
petition was also not been dealt
One
with.
alarming document, your lordship.
এরকম মানে
Yes.
আমি আমার মামলা বলবো না, কি
Don't even
কথা?
attempt that.
Have a father.
Those documents are not before. We should have served a copy on me. Then. But it is my submission.
My friend,
Let us
your
assume.
document.
Let us assume that the time petition was the basis for him to pass the order, and there was an adverse inference. My time petition has not been dealt with in the order.
Only
That
one
itself
Alright,
is an
so
unreason.
that's a very good ground for filing and recalling application. Go
Okay.
there, tell all these things. I think that's now Mr. Banerjee has come.
But have
Have your
only
lordship kindly.
in my mind, why are they preventing the father to visit?
No, no. That may not be the reason. Mr. Banerjee, your learned junior pointed out. You want to take some.
No, Mother, I'm fine.
You can kindly come to page 115.
My lord.
So there was a previous order.
Yes, my lord.
The court interacted with the child
Yes, my lord.
and was of the opinion that an opinion of the child psychologist is to be made. So directed you to take the child to the child psychologist to examine him or her, and
The child.
for
Him.
so according to you, pursuant to this order, you took the child to the child psychologist.
Sir, may I,
And
would your lordship forgive the interjection? We have a sealed copy of this.
that is, I will come to you. Please allow me to complete.
Yes, yes.
So the child psychologist examined the child, gave a report in a sealed cover to you. For ABC reasons, on the date fixed, that report could not be produced before the learned trial judge, and for which the learned trial judge, I think, drew some adverse inference against you, which prompted the learned trial judge to pass this
Maybe
order.
somewhere rightly also.
Maybe rightly, wrongly. So rightly, wrongly, whatever. So your submission, your contention is that the report was with you, but for some reasons, due to the advocate's fault or something, it could not be produced. If it would have been produced, this order would not have been passed. Best thing is that you go back to the learned trial judge, explain this, that this you have file an appropriate application. Your learned junior was saying that some time petition instead of filing of this. Explain that also. What occasion, time petition, what? Explain that and I think that's the best, and the court also can look into that and consider that.
Yes. May I just make one prayer? I will do that. In fact, that is what I had also wanted to do. Difficulty is, my lord, when we go now, even for this saying that your lordship had fixed the matter today, he had in open court said that because there is no order of stay, you put up the matter by way of a put up, and you mention the matter, I will take up the contempt and pass orders. So
That is Mr. Banerjee. My
Recalling-
you know that in some cases.
Look, I was only praying for this. Now that we are before this court and I have assailed it, your lordship is sending me back. I will go back. Your lordship will make it an order of the court. I will go back and file a recalling because it's the 31st March order at 115 is actually the cornerstone of my case for the revision also. Because court rightly came to the conclusion that speaking to the child without actually looking at this, it may not be prudent or fair on the child to be sent back. So till the court let the court consider this and pass whatever. So till the court considers this order, the contempt, your lordship, will stay. That is my only request. Otherwise, not the
next date fixed.
He's going to give up. He has in court.
What is the next date fixed?
5th of August, but the learned court has, the learned trial judge has said that give a put up and move on Monday if there is no stay.
Monday or
He was
Tuesday?
also there.
Monday or Tuesday?
Monday.
What has
Monday, my junior said, I bow down to your lordship, and this is what we also should have done. Because 31st.
May I only make,
Monday is a difficult
may I make only one submission? Ma'am?
Monday, sir, Monday is a difficult day. I'm directing.
We have
them
not
to file.
proceeded with.
No, my lord, this is saying here, I don't
I will
think he
record your
goes.
submission that you will not proceed.
Somebody
with
else
that.
goes and proceeds there.
No.
I will record his submission. I will record
Only
his-
issue, my lord, let him comply with the order. My lord, what
No,
happens?
my lord,
My lord, if this is
Sir,
the
only
way,
one thing, Tuesday, he will file
the
an application. I will direct the court to consider.
That's right.
Right way, this way, that way, if the court feels.
Correct.
to be
then, my lord,
fair,
may I only
I'm
make
also not
one more
staying.
submission, my lord?
I'm
Lordship,
also
my lord,
not staying.
since as a
No,
father,
lordship, I'm not staying the order.
my lord, I'm looking at a better picture today. My lord, today, the order 7, rule 10, which they have filed was rejected on the issue of jurisdiction. Thereafter, they have assailed this order, that is also for your lordship. Now, my lord, what happens, my lord, this suit, my lord, is now in a stagnant position. It is not moving. My lord, either way, it has to be.
Suit.
6 years, my lord, kindly appreciate.
Let us take this first
My lord,
because
kindly appreciate the
he's facing a
predicament of the
contempt.
father, my lord. Why contempt, my lord? Because of his conduct repeatedly, my lord.
Yes,
He's
yes.
one way or the other, my lord, he's not
Because of his
said.
conduct, so he wants that report to be placed.
Correct.
Let the court.
I don't mind the lordship also have a looking at the report. It's in sealed cover.
These two orders
Can I
again.
look at the report here?
Since the trial judge called for that report.
I believe, my lord,
That
this
is what
this
I'm
report,
also saying.
my lord, is
Let the honest
independent
judge
of my
consider
right
this.
to visit my son.
No, my lord, he
Assume
got
for a moment, my lord,
his right was not allowed on 31st March.
Make your submissions there. Make submissions there. I'm not
difficult-
saying that also.
No, my lord, the difficulty today, I'll tell your lordship, is that, my lord, this father, my lord, is starving to meet his son. My lord, he had made all his arrangements. My lord, he is also a businessman. My lord, he has his own job. So, my lord, for
Next-
2 or 3 occasions, my lord, he has tried.
Please consider. Next date is 5th of August.
5th of August.
So I will direct them to file on
I'll tell your lordship what happens.
22nd by a put up, and I will request the learned judge to take it up on 5th of August. 5th of August is not very
And
far
not
off.
to proceed with the contempt in the meantime, my lord. Otherwise, there is no point.
What
My lord, this
what
he says here.
why
I'm not saying
you
that-
say this, my lord?
So I'm not staying here. If you give undertaking that you will not proceed with the content for a limited period, I'm not staying this.
Let both the applications be heard together, the contempt and his recalling. Because if his recalling fails, then my contempt arises.
Yes, yes. After the recalling content.
Right.
After the
Because
recalling
what will
content.
happen, my lord, once he loses in the recalling, he'll again come back before
no.
this court.
Yes.
He'll again try to find out
After
a
the
way not to
recalling,
give the father
so
a
he
chance.
gives this undertaking, my lord, because he doesn't go. My junior had gone. Someone went and told the court they were not even taking an adjournment.
Lordship
They were
will
not
both
taking
the
an
matters
adjournment. So
together.
lordship will record that he's given an undertaking. that
Lordship
first
will-
the
I will record that.
Let both the
5th
matters
of
have
August.
analog
I will also record your statement that you will be filing on because 21st is a
I'll file on Tuesday.
21st is a 8 day. So 22nd you file with the and if you are saying that 5th of August, I request the learned
The
judge.
lordship will also make the suit time bound, my lord. Because they
I'm
are not proceeding with the order 7 rule
He
10.
can't get any order in my revision. He can't scream and get everything.
Suit
Order 7 rule 10 pending here before this court.
Mr. Banerjee, you are withdrawing this. I give you leave to file recall, and I record his undertaking that he will not proceed with the contempt till the recall.
Lordship will not record the undertaking. Lordship would rather direct both the applications to be heard analogously till such time, my lord.
No, my lord, there is a slight problem. There is a slight problem. This order is dated 4th of June 2025. Today we've crossed the 30 days. So
30 days, Mr. Banerjee, you have filed here. Section 14 is there.
I'll have to file that application, my lord.
To file that
So kindly direct the.
All right, I am directing without going into the issue of limitation because he has filed it here.
Yes. Kindly does that. That is all. That is all.
Father must get a right to see the son.
That's all.
Has to be.
Right, later.
That's right.
Because I was saying, your lordship will give me the 14 benefits. I go file it.
Once, my lord, they've admitted by the emails, my lord.
There's no admission by any email.
Your lordship knows.
Application under Article
It's certain that his application
Liberty,
will be.
you are right. Withdrawn without liberty, you cannot challenge. But this is withdrawn with liberty to file recall.
Yes.
That's the liberty. Then it's the second round.
It's a fresh cause of action.
Withdrawn with liberty. Mr. Banerjee, you are here. These are the law points.
Fresh cause of action, Millard.
Fresh cause of action. It's not decided.
It won't be a merger, but anyways, I'll come back before. If it goes, I'll have to come back again. Then this point won't be.
We are very certain we are coming back to your lordship.
No, don't be cheeky. We don't know.
Because he will never have a visitation. I know that, Millard. Come what may.
Mr. Banerjee, one thing. It's the other way around. You may fight, but it's after all.
No, father
the
must
father
meet.
has to meet the.
Must meet. This is outside the court. Both of us
Outside,
were
Millard, he's a
talking.
different person. He agreed.
Outside the court, I was agreeing. I'll tell you, Lordship, what is happening. The child is now 12. The child is adamant to not meet. And when he meets the father, and one thing, Millard, I can concede here. In one room, he doesn't want to meet the father. If the father is willing to meet him in a public place, I'll give that concession right now. That is my specific instruction. Then we don't have to go through all this. If the father instruction,
my ultimate goal is to meet my son uninterrupted by any third person. Any third person.
This instruction I can take because I was speaking to my instructing advocate here.
Mr. Banerjee, since both of you are going
When
back.
I spoke to him, I went and
Yes, yes. Since both of you are going back.
Put this in the recalling
Both of you are going
I
back.
will not
This is-
object.
both of you can make that submission.
Let
For
him
the
put that
learned trial,
in,
yes.
let
Yes,
him
yes.
put that in the recalling application.
Yes,
I will not object. I will agree
Yes,
to
you
it.
can also take
I will
that
agree
point
to
in the. Yes,
Yes,
he's
yes,
right.
because here what is happening is 2 days in one resort with the father, the child, I cannot force the child. But in a public place, the child wants to go, the child.
Public place, how long can he be there, my lord? How long
With
can
regard
he be
to this, I will not make any comment now because since I am sending you.
Yes,
both of
I
you back,
understand. Millard.
I'm not making
But this
any
we can
comment.
actually go
But
and
if
tell
this
the.
is the suggestion, you can make that.
Yes,
and you
I
can
will
also
make that
agree to
suggestion.
You can also consult.
I'll take
with-
Whatever I get is a win-win thing for me because 6 years, but I want my son to be with
Let
me.
him not keep saying it. He was also didn't even find out about the son when the son was in
Habeas
Pune
corpus,
or in Bombay.
Mr.
Nothing.
Mr.
For
Mr.
2 years, the
Banerjee-
father did nothing. Don't
Mr.
say what's in
Banerjee,
food.
don't go into
No,
those because after all it's.
I am also a father of 2 kids. Not
Other litigations,
right.
adversarial litigations, you can fight, but don't fight
Must meet.
with the issue of a minor child meeting the father.
No, in fact, not after we spoke, I spoke to my instructing counsel, saying because I'm also a father too. I don't know what's going to happen if I can't meet my children. So I said the father must be allowed to meet. So they've spoken.
You can also consult Mr. Banerjee says that he is agreeable.
Mr. Banerjee is a creature of instruction. But I know what kind of a person he is outside this court. But today what happens? He's submitting on instruction.
No, he's submitting on instructions. He says in a closed room, one room for 48 hours may be a problem.
Yes.
But you can start
Both
with.
in public places as
But
well as
according to him, you can start with some hours
That's
in
right.
a public place. That's his suggestion.
I am
And
most my good officers to convince.
it may be recorded to the most agreeable to that.
This
What I am
nothing recording.
agreeable is the
No,
interference
nothing
of
recording because that will
grandparents.
prejudice
Correct.
either of
But
your
I
case
will-
before the learned
I
trial.
will try and use my good officers to
You
prevail
are there,
upon
you
them
can
to
take
allow this
instructions,
in
go
a
there,
public place to
make
meet.
the submissions.
Yes.
If he makes the submission, I'll accept to it. I'm saying it in open court.
Yes.
I have instructions. I'll
This
admit
much I
to it.
should be able
Only
to.
one thing, doing anything will be modifying that order here. So that I do not want
No,
to do.
this minute I'll try and
That I do
I'll
not want
try and
to do
ensure that
that.
this submission is
There,
made before the
get
trial
it
court.
modified because he is filing for recalling or modification, whatever it might
नहीं,
be.
recalling ही करो दे.
So it can be done.
At the end of the day,
you
it
right.
is modified and the father gets to see the
So ওটা
son.
recalling
Nothing
বলিনি
but
তো আমি recalling বলিনি তো appropriate application বলেছি।
appropriate application করো।
So Mr.
I
Banerjee,
can
you
take a
can
modification to the extent.
yes, you can also modify.
Yes, yes.
Widen the scope.
Widen the scope, you
Widen
can do
the
that.
scope.
No, because
It
widening
helps
is
him. No,
only
I am
because
happy
of
if
this.
if he writes this in on black and white, well, we will agree to it. We will agree to it.
Well, this is a different sentiment. This is not something that we can fight over. I'll try and use my good officers to try and prevail upon them to at least agree to this.
Lordship is correct. We should start from somewhere.
একবার দেখা করতে শুরু করে তারপরে
দেখা যাক।
যে
হ্যাঁ তো আমি ওটা বলিনি yes Thank you.
He was
Yes.
very kind.
Rendering apology, my lord, I was engaged in another court.
Yes, yes. You want to move? You can move
If your
that.
lordship wants to take up, I have no problem, but I only appear only to begging apology.
Do you want to move today or don't want to move today? It's your choice. No, don't.
Secretary. I am the secretary.
He is in the yes, sir. He will be the calling.
That is why I asked you. That is why I asked you. If you want to move, here. If you want to move, to take up.
Tomorrow I will move it. But I am begging pardon, my lord.
21st of July.
Yes, yes. Monday I will come.
Yes. Very grateful.
Grateful, dear.
Sir.